Chapter 3: How to Contest a Child Support Default Judgment. Now, before I discuss the topic of how to contest a default judgment, I want to say this. When you contest a default judgment for child support, you must provide a reasonable explanation to the court about why you didn't file a response to the motion or petition during the time allowed by law. This may be difficult, and you should only attempt it if you have a legitimate reason supported by facts. You must also explain why you failed to respond or personally appear, in some cases, in court on the hearing date. Without a legitimate reason, the chances of having a default judgment set aside are slim to none. That's why it's best not to waste everyone's time, money, and resources. A few examples of legitimate reasons might include issues with the proof of service, an incomplete packet, hospitalization, a previously scheduled appearance in another court, incarceration, unaware of department change transfer, or perhaps a military deployment. With that said, let's dig right into how to contest a child support default judgment. Although I use the word contesting, what you're really doing is asking the court to allow you to respond to the petition or request for order, even though you're technically out of time. This is done through a reconsideration to the judgment or a request to set aside a default judgment. Note, if a request to set aside a default judgment fails, then seek a modification to the child support order. I will explain more as you read along. The two ways to contest a default judgment: reconsideration or request to set aside. There are two ways to contest a default judgment. Which way to do it depends on when you find out about the default judgment and when you decide to do something about it. Note, the DCSS will not assist in any way for you to obtain a reconsideration or set-aside judgment. It is strongly recommended that you seek the assistance of an attorney or paralegal to handle this process. However, if you absolutely cannot get the assistance of an attorney or paralegal, you can still complete this task. Reconsideration. You may seek to contest the default judgment by means of the court's reconsideration. If you find out about the default judgment within 10 days after the date it was filed, then you may request an order to reconsider the judgment made in lieu of no response being filed, or your failure to appear before the court. In order to ask for reconsideration, in most cases you can complete and file a FL-300 form and include other supporting information such as points of authority, declaration, and a copy of your response to the petition or motion. You must state the facts of the case and show the merits of your request. Here's a typical scenario for seeking a reconsideration. Donna serves Morris with a request for a court order seeking to establish child support for their 2 children. Morris receives the forms delivered by means of process service. He contacts an attorney and sets an appointment in order to complete his response and submit it to the court. But on the same day he was scheduled to meet with the attorney and hire him to help complete and submit a response to the court, Morris is involved in a car accident. His vehicle is totaled and towed away, and Morris is hospitalized. On the day scheduled for his court appearance, Morris is still in the hospital. That court hearing is the last thing on his mind, and he completely forgets about it. Meanwhile, the court and the other parent are both totally unaware of his accident. Donna has kept their children away from Morris ever since he was served with the legal documents. She doesn't know Morris's whereabouts. The court opens the case hearing. Donna is present, Morris is not. The court asked Donna if Morris was served the forms related to the court hearing. She affirms that Morris was served. The court checks the information to see if all forms were filed properly and on time. After confirming that Morris was served properly, the court also confirms that he didn't file any written response to Donna's request for a child support order. So the court grants Donna's request. The court cites Morris's lack of response as he was properly served but failed to appear on the scheduled date. The court is adjourned. A couple of days later, Morris is released from the hospital. When he gets home, it suddenly dawns on him that he has a court date coming up. Then he suddenly realizes that the hearing date has already come and gone. He missed it because he was in the hospital. Morris calls Donna and asks her what happened at the court hearing. She tells him that the judge made an order for $1,500 in monthly child support. He explains to her why he wasn't present in the court, but she still tells him it's not her fault that the court had ordered such a high amount without him being present. She tells him to take it up with the judge and hangs up the phone. Morris calls his attorney, who suggests that he can file for reconsideration from the court given the facts. Motion or request to set aside. You may also contest the default judgment by means of a motion or request to set aside the default judgment. This option might work if you find out about the default judgment after 10 days but prior to being in effect for 6 months, 180 days, or more. Using the example of Morris and Donna, if Morris hadn't been so proactive after learning that he missed the court hearing, let's say that he had waited 3 months or perhaps until the child support order was enforced through his employer, like many people do, and it was within 6 months of the default judgment issuance, then he might be eligible to file a motion to set aside. The best strategy. In any case, filing a request for reconsideration or a motion to set aside the default judgment, even if filed within the allowed time period, will not guarantee that the court would grant your request. Even if you feel you have a good reason or reasons and you provide supporting documents, it's still up to the court that has jurisdiction over the case. I don't want to discourage you, but I don't want to mislead you either. Based on my experience, here's the best strategy. When you file either of the two, for reconsideration or to set aside the default judgment, you may also want to request for the court to modify your child support order as an alternative, and in lieu of denying your request for such a reconsideration or motion to set aside the default judgment. The court might agree with it. When you seek an alternative, here's what you're asking the court. If you decide to deny my request for reconsideration or motion to set aside the default judgment of your present judgment, then as an alternative, can you modify the existing child support order or set a future calendar date to come before the court for a modification or change to my child support order? Please note, in some cases, the alternative is not an option. In those cases, you must file a separate request for Order FL-300 to modify the child support. You can file the request for order at the same time that you file for reconsideration or motion to set aside the default judgment. Just remember that whenever you seek to modify a current child support order, you must mark the change box on your request for Order FL-300. Let me give you a scenario. Continuing forward with the story of the same couple, Morris and Donna. After realizing he missed his court date, Morris retains an attorney. Here's a scenario with Morris and Donna. The attorney explains that Morris's unforeseen accident, which put him in the hospital, hindered his ability to seek a continuance, prepare and file an answer or response, or appear before the court on his hearing date. She further explains that due to his mistake, inadvertence, surprise, or excusable neglect, he could file a motion within 6 months after service of written notice of entry of the judgment. That's the reason for his request for reconsideration. The attorney then advises Morris that in addition to seeking a reconsideration of the default judgment, he should also ask for an alternative or separate request for order filing for child support modification order in lieu of the reconsideration being denied by the court. Morris is confused, but the attorney explains that it wouldn't hurt to ask the court to modify the existing child support judgment. He goes on to say that it's a better alternative than having the court deny his request for reconsideration. The attorney further explains that even though there isn't any case law or family law code pertaining to an alternative or request for order filing, the court might still grant it in lieu of denying the entire case. Morris agrees with this strategy. The attorney tells Morris that if the court grants the modification to change child support and denies the reconsideration, he will still be responsible for child support at the currently ordered amount up to the commencement of the new modified order given by the court. As illustrated by this scenario, an alternative or request for order filing to change the present child support order may be the best solution. That way, your child support order can be modified using calculations based on your updated income and expense form FL-150. The purpose of contesting a child support default judgment is to remove that judgment and have your case heard on the facts and merits. The purpose of having your case heard on the facts and merits is to obtain a fair child support order using the calculation based on your actual gross income. Request for modification to a child support order. If you have already allowed over 180 days to pass without responding to the court to contest its default judgment, you may still seek to change that judgment through a modification of the child support order. You may reasonably seek a modification for your child support case every 6 months, 180 days. If the income earned by you or the other parent changes by $100 or more, or if shared parenting time, visitation, has increased or decreased, or you seek to adjust child care expense payments, or financial issues with health care such as co-pays and costs not covered by insurance. If the current income and/or the shared parenting time with children is different from what the court has on record, then you can seek a change or modification of the child support judgment. Typically, this is a fairly easy process. You must complete a request for order FL-300 to change your existing child support order. You'll include a declaration, an income and expense form, attach a month's worth of paycheck stubs, a calendar outlining shared time or a visitation with children, information for health care, if necessary, and any other information you feel will help your case. That concludes Chapter 3. From the book Child Support Orders Matter, written by Xavier M. Marshall, Sr. We hope that you found the information provided helpful. To receive more helpful information, subscribe to this channel. If you have any questions or comments, you can email us at maddadfam@gmail.com. That's maddadfam@gmail.com. To send a monetary contribution, you can Cash App us at $MakeItHappen007. That's $MakeItHappin007. Venmo at yourservice951. That's ATYOURSERVICE951. Or send a check or money order to 4192 Brockton Avenue, Suite 203, Riverside, California 92501.